Good afternoon. Thank you for joining us again for our live Zoom webinar dealing with the issue concerning child custody disputes and battles part 4. If you're wondering why is it stipulating part 4, there was part 1, 2 and 3. It has been done. You are welcome to view those specific live webinars. It will be available. It is available on YouTube, or you can go to talalaw.co.za/past. You should be able to find it. Otherwise, we're waiting for some participants to join us on Zoom. It will take another minute or two, and we can start the webinar. On the screen, there are a few questions that were posed by our registrants, and I will try my best to answer them. If you are watching this webinar from Facebook Live, these specific questions will be given preference to. However, please feel free to pose whatever questions you have on Facebook Live, and I will try to answer it for you. It has to be on the Advocate Muhammad Abdullah Facebook page. I cannot see any other pages while I'm streaming this video live. Please head out to that specific page, Advocate Muhammad Abdullah, the Facebook page. While I'm letting all the participants in on the live Zoom webinar, please feel free to pose whatever questions you may have. I will try my best to answer them. I'll give it one more minute, as it is a pre-scheduled live webinar which you had to register for. I think we can begin. Thank you to all the participants who have registered for this live Zoom webinar. I thank you for the questions which you have posed. I see a question on Facebook Live. Yes, you can pose whatever questions you have, and I will definitely get to it today still while this webinar is taking place. And thank you for all the participants on Facebook Live. We have quite a growing population of people watching these videos from all over South Africa, and I can presume other countries as well. This morning I had a webinar with somebody from Saudi Arabia regarding some family issues, and obviously sometimes I get to consult with people, expats, people from the UK, United States. So these videos make its way around the world, and you are welcome to obviously pose whatever questions you may have live. I'll be keeping an eye on the Zoom page, the Zoom registrants. I have to let them in, and at the same time see what additional questions they pose, and at the same time I'll have to keep an eye out on the Facebook page. However, feel free to pose whatever questions you have on the Facebook page, and we can deal with it in that specific fashion. Okay, let us begin. The first question which I have: the father and I have agreed on a parenting plan before our second court date in the children's court. Will this get signed off by the magistrate when we go? The long and the short of it would be yes. The court would obviously have to be convinced that the parenting plan which you and the father of the child have agreed to is in the minor child's best interest. But generally, if the parties have come to an agreement regarding a parenting plan, the court would endorse it. Why must the court really get involved if the parties have resolved the specific issue at hand? So that is the case. The court will generally endorse it. However, if there are any technical issues in relation to the parenting plan which the court wants to deal with based upon previous allegations made in the application or previous allegations made in court, the court would obviously want to first address that. But the long and the short of the matter is, if the parenting plan is fair and both parties are happy with the specific parenting plan, the court will make it an order of court. I think that answers question number 1. If there is any additional questions that you would like to add to that via the Zoom participants, you're welcome to do so. I'm just letting some people in quickly. Just a bit of a word for the people watching from Facebook. This is a live Zoom webinar which you could have registered for free of charge, and your questions would have been sent to me before the webinar takes place, and I'll paste it onto the screen. Many people decide not to pose any questions because they just want to participate or listen in live. At the same time, many people cannot make it on the live Zoom webinar. However, they register, and later on they will receive a link, a YouTube link, where they can watch this video at their convenience. So therefore, I have another few questions. However, if you have any specific questions regarding child custody dispute and battles, part 4, how do I get the best out of my case? The idea basically is, you are busy with a child custody matter, a child custody battle, you are dealing with it. However, your question is, I have a specific problem, or this is where this matter is currently at. What can I do? What advice do you have, advocate? Advocate, I am struggling here. What can I do? What advice do you have? Assist me, direct me, guide me. That is the type of questions I want for you to pose. Obviously, you are allowed to ask, and I also do welcome any specific legal questions you have on the process. For example, I live in Cape Town, the mother lives in Johannesburg. Which maintenance court should I go to if the kids are living with the mother? Obviously, the answer would be the Johannesburg maintenance court, because the kids are living there with the primary caregiver being the mother. Okay, we have a live question. Let me copy it quickly into our screen. The mouse is giving me a problem here. Okay, that looks okay. Copied it, okay. And let me get it to the screen. So live question number 1. The live question is as follows. Does a 12-year-old have a say with a parenting plan? The Children's Act, and obviously the law, it encourages the participation of children in matters where their lives are relevant, where whatever decisions are being made affects them. It also depends on the maturity of the child. If the child is 3-4 years old, quite young, he can speak or she can speak, but not necessarily matured, then under those circumstances, the court will most probably give them a bit of a hearing, but not necessarily consider what they have to say. However, if the child is most probably, let's say, 12 or 13 years old, and his or her reasons for wanting to reside with one parent are sound reasons, valid reasons, the expert will obviously have to note it, and they can give their opinion on that. But it will not be seen in isolation. It will obviously be considered after consulting with the father, consulting with the mother, and the court will make some type of a decision regarding that. For argument's sake, if the child wants to live with a dad, the child currently lives with a mother primarily, but the child wants to live with a dad because the dad lives closer to the school, and the child's friends are all closer to the dad's home, and the child is quite old enough, like 16 or 17 years old, to look after himself to a certain extent. And he wants to live with a dad because things are easier for him. He's in matric, or he's going to matric, and it will just make more sense for him. So the court will listen to that specific aspect. And the court might give it a much more weight than the mother and dad fighting over who should look after the child if all else is equal. However, if it's theoretically better for the child to live with the dad, but the dad doesn't have the facilities, the time to look after the child, when the child comes home, nobody will care for him, then under those circumstances, although the child wants to live with the dad, he's pleading to live with dad, but dad cannot care for the child. Or the place is too small, I don't know, but the court might make a decision under those circumstances. Thank you, child, we have listened to what you have to say. However, we think under the circumstances it's best if you remain with mom, although you want to live with dad. Therefore, I hope it answers the question, does a 12-year-old have a say with a parenting plan? Yes, we have to listen what he or she has to say. However, we have to listen to all the parties have to say, and then we have to make a decision based upon that. And I'm one of the practitioners who encourages the court or the social worker or the psychologist to find out from the child, get the child's buy-in. That's my new term which I'm using, and I'm developing all these new phrases like toughen up and own your case, and now buy-in. Let the child buy into the system. Let the child know that this decision for you to live with mom or with dad was considering what you want. It's very important that we do that. I hope that answered that specific question. It's a bit hot here in Cape Town. There's another live question before I deal with the other questions as well. Let me try to copy it. This technology is challenging me today. I don't know why. And after this live question, we will deal with one of the registered questions. Okay, this live question says the following. I need to do something here first. There it is. Hi advocate, may I ask a question? Of course you may, and you are welcome to do so. All of you are. And if so, if a mother takes the children out of the house without my knowledge and moves into a unsuspected new partner's home, what can I do? We did fill in form number 2, but they only gave me a court date without doing anything. There are no allegations other than she is not happy in the marriage anymore. No cases pending. The mother and the father, I'm being general here, and I'm not specifically answering your scenario based upon this. You're giving me a few sentences. I might have missed something. The general way in which I consult with these type of important issues is to ask you 1,000 questions, literally 1,000 questions. And then based upon that, those answers you provide me with, I will advise you on the best course of action. But because the information is limited, I try to be general, but at the same time, take it from a point of view that it might not be correct because you're only giving me that information which you think is relevant. Other information might be relevant as well. If you are concerned that the minor child is being neglected or not being looked well after by the other parent in this new unsuspected new partner's home, you need to have valid concerns, valid reasons for that, to stipulate that. For example, the child is being abused, the child is being neglected, and so on. Then you have a good reason to approach the court urgently, maybe the High Court, and tell the court, these are the circumstances. I want the minor children to remain in my primary care until these issues are being resolved. The marriage has broken down. It's clear to me one of the parties has moved on, and they never asked your permission, but that's something in the past. It happened. I would expect the party to ask for the permission, and they have not asked for permission, but it's a reality, it's a factual thing. So I cannot dwell over the past. I need to deal with how can I deal with the future. Maybe the kids are well looked after, I do not know. So you need to determine whether or not the kids are being well looked after. And if they're not being well looked after, you need to make a decision. Am I going to step into the situation, be aggressive here, and make an application to court and stipulate to the court that the kids are not well looked after? I can look after these kids very well, and if they are going to be in my care, they will not be neglected, and so on. So that's the basis where I'm going to. The challenge I see with going to the children's court with respect to them the process might be a bit slower than going to the High Court, which is a bit faster. But obviously the High Court costs more money, it's very expensive, and it's COVID-19, and the courts are very apprehensive and not very willing to assist people like they used to assist people in the past. If you feel that the children are being neglected, maybe get a social worker on board as well. Another consideration. When the kids are with you, have the social worker come over and consult with these specific kids and find out. But if the marriage has broken down and the mother decided to move on and move to somebody else's home, get a new partner and take the kids with her, and the kids are fine, and that is, in my view, the situation. If you have a problem with that situation, you need to show the court that it would be better for the kids to actually be living with you, and you can care after them. You can take care of them much more better than the mother can take care of them. That's the advice I have. You can add any additional information to your question, and I'll be happy to answer that. So you will be the Facebook Live questioner number 2. And I have a comment over here, says, thank you so much, you're welcome. That will be question number 1. You're welcome anytime. Feel free to pose whatever additional questions you have. Let me get back to the second question of the registrants. It goes as follows. I have 3 minor children and their father lost his job recently. I want to approach the court for a court order to claim against his pension fund payout for his kids. Will I be able to apply for it? It's a difficult one, because if the father is paying whatever maintenance he must be paying, whatever support he must be paying, and then obviously you shouldn't be able to attach whatever pension fund there is. If the father is not paying maintenance, then obviously there's a reason for attachment. If you are afraid that the father will dissipate the funds, they call it the anti-dissipation order. If you are afraid that the father will spend the funds and use it up, and there will not be any maintenance available for the minor children, then you can approach the court, and the court can make basically a anti-dissipation order or gagging order, depending what term you want to use, basically ordering the pension fund to pay monies out to the parents. Alternatively, maybe possibly having a lump sum money being paid to a trust account, and that specific trust account can pay the money out as maintenance. You can be creative over it, but there must be a basis for that. If somebody gets a pension payout and he is still paying his maintenance, there's no reason for you to obtain such an order. So the court must be convinced that I'm infringing this person's right to use his money. The same way, if I get paid a pension fund out and I'm paying my accounts at whatever place it is, they can't now say, no, we want to attach all this money as long as I'm paying my accounts on a monthly basis. And the same way when it comes to pension fund. There are cases in the past which I've dealt with where the party was in arrears with child maintenance, did not pay child maintenance, does not want to pay child maintenance, and then the court basically attached the pension fund or ordered the pension fund to pay the maintenance on a monthly basis to the parent who is a caregiver of the minor children. So that is possible to happen. My advice to you is go to the maintenance court, speak to them, see what they have to say, and they can make those specific relevant orders. On the live chat, regarding question number 2, says, thank you very much. You are welcome, and you are welcome to pose any additional questions you may have. I'm just going to the Zoom again, letting some people in. Okay, there it is. Every minute or so I have to just double check if anybody's knocking on the door. So continuing with our topic, child custody disputes and battles part 4. How do I get the best out of my case? And I hope that you would possibly benefit from this. Remember, the idea here is not for me to answer specific legal questions like how do I do this or how do I do that. You can go online, you can go on the internet, you can watch my previous videos, and I will most probably answer that for you. I would have answered it for you. However, if you are struggling with a specific aspect regarding your case, regarding your child custody case, the matter might be pending in court, there might be issues, I do not know. Under those specific circumstances, on that basis, please feel free to pose questions. You'll get the best out of this webinar. However, if you have a general question and you don't know the answer, please feel free to pose it in any event. Question number 3. This is one of the pre-registration questions. The father of my child is on drugs. Is it possible that my new husband can be the child's guardian should I pass away? That is a very interesting question. It happens often where I get that question posed, where a client comes to see me for whatever contact rights and so on. Generally, when it comes to relocation or the other party is not much involved in the child's life, or the specific parent remarried and is caring for the child, and that specific parent is now concerned, if something happens to me tomorrow, must the child now be flown down to the other party? Although the other party never cared for the child because the other party is a co-guardian with me. Now, in terms of the Children's Act, if you are the sole guardian of the minor child, let's say there is no other parent, in your will you can stipulate that at my death I would like to make my guardian my new husband, my aunt, my uncle, my sister, which happens often, where a sibling gets appointed as a co-guardian, as a guardian in a will. You can do something like that. However, if the other parent is the co-guardian and you pass away, then automatically he or she becomes the sole guardian of the minor child. What I advise people to do under these circumstances, you have one or two options you have. You can either approach the court and have guardianship rights conferred or appointed to the other party. For example, let's say you've remarried, you're living with your husband, and now the term they use is assignment, and you'll have guardianship rights assigned to your new husband, as opposed to him adopting the child and both of you have guardianship rights over the child. So you have that specific rights assigned to your husband. For the sole reason that in case there's problems, you cannot be found, and your husband can act as guardian for the child, contractual stuff and so on. But the challenge with that is, I would say, is what if tomorrow you guys divorce, there's problems, and then we have a situation whereby you divorce and we have somebody who's a third party who is also guardian over the child. Same with adoption. The other party can adopt the child with you, and tomorrow you guys divorce. This adoptive non-biological parent has rights over the child, and the biological father, let's say that is the case here, he doesn't have any specific rights because he gave off the child. So they can become very complicated. What I advise, and this is my advice which I have for the specific clients, just 1 second quickly. I hope you can see me. It seems to me my screen has stopped. 1 second, please. I think this is what happens if you're doing a Zoom webinar and so many platforms are on your PC at the same time. Okay, I'll nonetheless continue with my discussion, and hopefully my screen should be able to take care of itself soon. Okay, nonetheless, I'll continue, and hopefully later on we can resolve this issue. So my suggestion to people is, when it comes to that specific scenario, is to inform the other party that the moment you pass away, the moment you're no longer around, that at that specific time, that specific parent makes an application to court, and asks the court that parental rights and responsibilities can be assigned to that parent. So you do not make an application to court before the time. You make an application to court. You advise a specific relevant party who you want to have parental rights and responsibilities, who you want to care for the minor child. You advise that specific parent or person to make an application at your demise, urgently, immediately, for you to be the primary caregiver, or for him to be the guardian holder or primary caregiver of the minor child. To me, that makes more logical sense, as opposed to adoption and assignment of guardianship rights whilst you are alive. And more than likely, in all honesty, you will most probably live until the minor child becomes an adult. And under those circumstances, there was no need for you to have assigned or have the minor child be placed under the guardianship of the other parent or other person. So I hope that answered that specific question for you. I'll deal with the next question. It goes as follows. What do I do if the mother of my child does not want to agree on a parenting plan? We are now 2 years in court. Now, that is a very common question, where people come to me and ask me that specific question as to, we're in court, we're trying to agree upon a parenting plan, but the other party is not willing to agree upon a parenting plan. What can I do? Basically, then you must litigate the matter. You must go to court and let the court make a decision. You cannot force someone to agree upon a parenting plan. That is unfortunately how it is. If someone does not want to agree upon a parenting plan, that is his or her prerogative. And if he or she wants to be difficult and feels that the court will make a different decision, then he or she is welcome to do so. Therefore, if someone is not willing to agree upon a parenting plan, my advice to you is get finality on the issue, come to a point where the other party is not willing to do so, the parenting plan and negotiations cannot be finalized, and under those circumstances, done, let us proceed with going to court and finalize this matter. That's the best advice I have for you. Okay, I have another question, another one of the live questions, the third live question. Let me get to it quickly. And I apologize for the video. I think the Zoom people can see me very well, but the people on Facebook Live cannot see me. So I apologize for that if you are watching this video via Facebook Live. Yeah, the Zoom people are giving me a thumbs up. They can see me perfectly well. It seems to be a streaming issue. I guess it happens if you dealing with Zoom and Facebook Live and all these specific technologies at the same time. It can cause a bit of challenges. Okay, but let's get to the third question. It goes as follows. Hi, advocate, regarding another matter. A baby was born out of wedlock. One second. There I am back. Nice to be back. Okay, let's get to the third question. Hi, advocate, regarding another matter. Baby was born out of wedlock. The social worker removed the baby from the mother soon after birth. Okay, so parents were married, child was born, the social worker came and removed the baby from the mother soon after the child was born. The father attempted to register the child on his surname but was denied so by the Home Affairs Office, but the mother may. Generally, if the father's name is not mentioned on the birth certificate, then the child will have the mother's surname. But let me go on. Due to the fact that the social worker removed the baby, there is a case open at the local magistrate's court ongoing. Why can the father not register the child that is currently partly in his care with the help of the safe house for the children? Is this process not perhaps against the Constitution, discrimination? Thank you. Of course it is against the Constitution. I mean, the father should have just as much rights over a minor child as the mother. I know they want the mother's consent. If the mother does not give the consent, and then obviously there's a dispute between the parents, then one parent cannot just go ahead. It can be a bit complicated because the mother will have to verify and confirm that he is the father of the child, and that is most probably why they want the mother to be the one making the necessary application. Otherwise, tomorrow any woman can fall pregnant, and then she can just say, John, down the road, please come and, accept paternity. All of a sudden, John becomes the father, child at John's surname, and that's that. Alternatively, John just goes to the Department of Home Affairs and says, I'm the father of that specific child, without the mother confirming it. There we have it. He's the father of a child, although he might not be the actual father of the child. So under those circumstances, I can see there could be possible issues, especially under these specific social welfare issues. you need to go to the Department of Home Affairs and find out exactly what the reason for that is, if it's a logical and a rational reason. I can see the only technical possibility, as I mentioned earlier on, for them denying assistance would be that the mother needs to verify that you are the father of the child. But at the same time, a father can approach the Department of Home Affairs and confirm his paternity, and his details has to be inserted into the registry of birth and death registration register. So that is possible. That can be done at any point. So if on the child's birth certificate it specifically states that there is no father, father is not identified, the father can come to Home Affairs and prove that he is a father, and his details must be inserted into the register. So I hope that sorts that out, and hopefully there won't be any camera issues going forward. And we're running shortly out of time, so I'll deal with the next question. Question number 5 are the people that registered before the time, if you're watching this. I do not have a lawyer. Is it necessary to have a lawyer in High Court? My ex says he will take me to the High Court. I firstly would advise anyone, it is always advisable to make use of legal representation. The same way, when you're building a house, you make use of a builder. When you're dealing with your accounts, you make use of an accountant, and so on. So I will not discount the advantages of making use of legal representation. But regarding the legal question, is it necessary or a requirement in our law that you must make use of a lawyer or a legal practitioner registered with a legal practice council or whatever law is applicable at the specific time? No, you can represent yourself in any legal matter. In the Children's Court, in the High Court, in a civil matter, if somebody sues you for whatever, you can represent yourself. You can sign your own documentation, you can file your own documentation. You do not have to make use of a lawyer. So that's very important to note when it comes to legal proceedings. But at the same time, as I mentioned earlier on, it's always advisable. If you cannot afford a lawyer, then there are other ways of doing it. Watch this video, for example. Then you can, or post questions regarding that. Go to the library. Go to a law library. Some universities have law libraries. Most should have it, or all should have it, that offer law. Go to the public library. There might be certain textbooks on the law online. You can Google and stuff like that. Find out information. Go to the court and ask the clerk how the process works, what you can do or what you cannot do, and so on. Then you can represent yourself, and you'll get a better chance of getting a better results as to not knowing anything and going into a matter blindly. So that is my advice on the question: should you have a lawyer? You do not have to have a lawyer. You can represent yourself. And the last question, unless any other questions come through on the Facebook Live. I see no questions on the Zoom, no additional questions on the Zoom. Let us move on. The last question. Question number 6. We are currently separated and married. Can I approach the court for a parenting plan? So the parties are married. No issues regarding that, as opposed to being unmarried and just having a child. So they are married in terms of the law, but they are separated. The question is, can they still approach a court for a parenting plan? Yes, you can. You can approach a court for any relief, even if you are married to the other party. You do not have to be divorced or approach the other party whilst you are divorced. Therefore, although you are separated, you can approach a children's court if there is a dispute regarding the kids. The law doesn't say you must first get divorced before we can assist you. You can approach a children's court if there is a dispute, and the children's court will obviously have to follow procedures in trying to get the parties to agree upon a parenting plan. If the parties cannot agree upon a parenting plan, and then the normal procedures must be followed. The matter must run its course. For argument's sake, how does it run its course? the applicant will come to court, or the complainant will come to court, and he will say whatever he wants to say to court. The other lawyer, if there's a lawyer the other side, or the other party representing himself, will ask him her questions, put his or her version to the witness on the witness stand, and then later on, you will come on the witness stand and stipulate your case, and the other party will ask you questions and so on. Then the court will make a decision based upon all the information and evidence before it. Usually there will be an expert report, an expert recommendation, someone who knows about your case, who who made an investigation into your case, and who provided a report on your case. And the court will specifically look at that and make a decision based upon that. I hope that answers your question. You can go to the Children's Court for a parenting plan, even though the parties are still married. What often happens is, and it happens a lot in my profession, parties are separated, they're still married, they have problems, they might divorce, they might not divorce, but one of the parties are concerned that the child will be neglected, or the other party will just come and collect the child, or phone the police, whatever the case may be, because there's a dispute. With whom might the child be? Well, the parties are separated. Might the child be with the mother? Might the child be with the father? If there is a pending divorce, there's something called a Rule 43 in the High Court. You can get interim relief. The court can make an interim arrangement, but that can take some time, and the matter might be very urgent. Then under those specific circumstances, the court can make a quick ruling and say, after obviously applying its mind to it, and saying in the interim the kids must live with the mom or with the dad, or the parties can say, look at here, judge, we are separated, we might be separated forever, we might not want to get divorced, but we need some finality on with who the children should reside with. The court will obviously have to apply its mind and make a decision on the specific issue. And that's it. We had 6 pre-registered questions, and we had 3 live questions. If you have any additional questions, you are welcome to pose it. We are not running out of time, but usually these type of videos are about 40 to 50 minutes, and I try to keep it under an hour. But if you have any specific question, either from the live Zoom viewers, they seem to be fine, or from the Facebook Live viewers, you are welcome to pose it. Please note that I can only take questions or see questions that are on the Advocate Mohammed Abdullah Facebook page. Please follow that page if you are interested, and that's a platform I make use of. You might see this video on other specific platforms, like the Our Law platform and a few Facebook groups, but I'm not watching that specific screen while I'm doing these specific webinars. I have a comment from the last person. She says, thank you for your advice, Advocate. Much appreciated. You are welcome, and thank you for your question. That's also very much appreciated. If there's nothing else, thank you, everybody. We have reached the 40 minutes time for the specific webinar. If there is any other questions, I'll be happy to answer it. Otherwise, I hope you have a lovely day further, and thank you for registering for the specific webinar. Thank you for your questions, and thank you to the live Facebook viewers for posing those specific questions. And the more you pose these questions, you're posing questions that other people can benefit from. So I'm answering your question, I'm applying the law to your specific circumstances, but there might be a few thousand people out there that have has exactly the same specific question, or the same answer, sorry, it's the same problem. And by watching these videos and with you participating, we're giving everybody an opportunity to learn and benefit from that. Please share this video if you liked it, and hope to see you next time. Thank you. Bye-bye.